There was a pair of glasses on the evidence table, brown frames, left lens scratched white across the middle. One arm snapped off so cleanly it looked as if it had been cut with a knife. I have seen stacks of files, photos, broken phones, torn jackets, bloodied shoes. But those glasses stayed with me. That is why I am telling you this story. They were not expensive glasses. I knew that the second I saw them. The kind a person buys because they need them, not because they want them. And that mattered to me because by the time those glasses reached my courtroom, one man was still speaking as if the worst thing that happened that night was that his evening had been delayed. Subscribe to this channel. I do not say that lightly. I say it because if you are still listening at this point, you are exactly the kind of person who should hear what comes next. Subscribe. Then I will keep going. Her name was Maria Santos. She was 52 years old. She came into my courtroom with a canvas grocery bag folded twice under her arm and a pharmacy envelope tucked into it. She moved slowly, but not for sympathy. She moved slowly because her left hip still hurt when she turned. Before she sat down, she said to the clerk, "I am sorry if I take a second." I wrote that down. What I remember most about Maria was not the cast that had already come off or the bruised photographs or the stack of bills. It was the way she kept smoothing the same piece of paper with the side of her hand whenever somebody else was talking. It was a bus pass receipt. She had brought it because she wanted the court to understand that after the crash, she had to stop driving with her daughter for 3 weeks and take the number 92 bus to work. She was not a woman who had come to court looking like a victim. She looked like a woman who had other things to do. She worked as a cafeteria manager at an elementary school. She had 2 grown children. She cared for her older sister on weekends. When she testified later, the line that stayed with me was simple. She said, "I kept thinking I had the walk sign, so I did what people are told to do." There was no speech in it, just the fact. The defendant was Ethan Calloway, 28 years old, good suit, good watch, haircut sharp. He came in with his lawyer half a step behind him, which told me a little more than he meant to tell. Most people follow counsel into a courtroom. Ethan Calloway entered as if the room would adjust to his pace. He did not roll his eyes. He did not huff. Ego is often quieter than that. He leaned back before anyone told him to sit. He checked the cuff of his shirt twice. He looked toward the gallery only when he thought someone might be looking at him. When the clerk told him to turn his phone all the way off, he smiled and said, "Of course," in a tone that suggested the request itself was a little beneath him. When Maria Santos entered, he did not look at her, not once. He looked at me. He looked at the prosecutor. He looked at the police officer near the rail, but not at the woman whose body had hit the pavement because of him. I noticed things like that. A courtroom teaches you to. If you are not subscribed yet, do it now. I'm going to tell you something that did not come out until the 3rd day of testimony, and when I heard it, I had the witness repeat it back to me word for word. That moment changed the whole shape of the case. I do not want you to miss it. The incident happened on Tuesday, October 8, 2019, at 7:14 p.m. at the corner of Broad Street and Elmwood Avenue in Providence. I remember the time because it appeared in 4 places: the police dispatch log, the ambulance record, a traffic light timing sheet, and the still image from a laundromat security camera across the street. Once the same minute keeps meeting you from different angles, it stops feeling distant. Maria Santos had finished work late because another employee called out sick. She stopped at Rivera Market and bought rice, milk, and cough drops for her sister. The store receipt was time-stamped 7:03 p.m. She left through the side door, crossed toward the marked crosswalk, pressed the pedestrian button, waited, and stepped off the curb when the signal changed in her favor. Ethan Calloway was driving a white BMW X5 southbound on Broad Street. He reached the light, slowed, and made a right turn on red toward Elmwood. That much was not in dispute. What was in dispute was whether he looked where he was going, whether he was touching his phone, and whether he understood in the moment after impact that another human being mattered more than his own schedule. Officer James Hanley arrived within 5 minutes. He testified that Maria Santos was on the curb, seated upright, holding her left wrist against her chest. Her grocery bag had split. 1 carton of milk had leaked onto the sidewalk. Ethan Calloway's BMW was 15 feet past the crosswalk. Officer Hanley said Ethan told him she came out of nowhere. I wrote it down exactly. A young witness named Terrence Lee was waiting at the bus stop. He said Ethan got out, looked first at the front passenger side of the vehicle, then at Maria, and said, "My mirror barely clipped you." Terrence said Maria answered from the ground. She said, "Sir, I cannot get my arm under me." I wrote that down too. There is a legal detail most people do not know, so let me explain it the plain way. When a pedestrian has the signal in a marked crosswalk, that space belongs to the pedestrian. A driver does not get to claim half of it because the turn seems easy, or because traffic is light, or because dinner is waiting. The driver waits. That is the rule because anything less invites guesswork, and guesswork gets people hurt. The file that came to me was not one citation. It was failure to yield to a pedestrian in a marked crosswalk, use of a handheld device while operating a motor vehicle, negligent operation causing bodily injury, and failure to provide full information at the scene. Ethan stayed long enough to speak with the officer, but he did not give Maria his insurance information, did not ask where she was being taken, and left before the ambulance doors closed. That last part always matters to me. The first minutes after harm are often the cleanest window into a person's priorities, not because people are polished then, because they are not. If somebody is frightened and still moves toward the injured person, that tells me something. If somebody is worried and still makes sure help is coming, that tells me something. If somebody starts measuring inconvenience, that tells me something too. From where I sit, I see how people enter a room before they remember to manage themselves. Maria Santos came in with her daughter, Isabel. Maria held the rail on the short steps. Isabel carried a brown accordion folder with hospital bills, therapy notes, and photographs. Neither woman looked around much. They were there for the case, nothing else. Ethan Calloway entered faster, coffee in one hand, keys in the other. He set the coffee down at counsel table and adjusted his jacket before he sat, as if arriving mattered more than being ready. His father was in the second row. I knew the name. Charles Calloway owned 3 car dealerships in the county. That did not decide a thing in my courtroom, but it explained the ease Ethan wore like a second shirt. By the time the first morning was done, I could see the divide clearly. Maria Santos was there because something happened to her, and she needed the truth said out loud in a room that counted. Ethan Calloway was there because something had happened to him too, at least in his own mind. Trouble, delay, exposure. That difference may sound small. It is not. I have told this story before, to colleagues, to my family once, and every time I reach this part I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it. The first wave of evidence established the ground under everything else. Officer Hanley described the scene. The city entered photographs of the crosswalk, the torn grocery bag, the scratch on the passenger mirror, the glasses, the spilled milk, and the bruising on Maria's hip and left shoulder. The ambulance report showed a distal wrist fracture, deep tissue bruising, and rib pain. Her out-of-pocket losses were listed at $7,116.82 before lost wages were even added. Then came the everyday costs that people often ignore because they do not look dramatic on paper. 12 missed shifts, 9 physical therapy visits, $43 in rideshare fees to medical appointments because her daughter worked mornings, a replacement pair of prescription glasses, a metal grab bar installed beside the front steps of her duplex because for a month she could not trust her own balance when carrying anything in her left hand. During that first wave, Ethan Calloway leaned over several times to whisper to his lawyer whenever a receipt was marked, not in panic, not with urgency, more with irritation. The expression said he believed the room was adding ordinary life up too carefully. Maria Santos did not whisper once. She listened with both hands folded over the same pharmacy envelope. The second wave made things harder for the defense. The laundromat camera did not show the whole impact with perfect clarity, but it showed enough. It showed Maria stepping into the crosswalk on the signal. It showed the BMW rolling into the turn without a full stop. It showed the brake lights coming on only after contact. Good evidence does not always come in a grand form. Sometimes it is just one ugly angle that will not lie for anyone. Then the prosecutor introduced cell phone extraction data for Ethan's device. No sent message at 7:14 p.m. That was the defense point, but there was an open text thread active from 7:13:48 until 7:14:11. The screen had been touched 3 times. On its own, that detail might not carry enough weight. Sitting next to the video, the witness testimony, and Ethan's own statements, it had weight. Terrence Lee testified in a way that made me trust him. He did not try to sound bigger than he was. He said he saw Ethan look down before the turn. He said after the impact, Ethan stood near the mirror and said, "I said I'm sorry. What do you want me to do? Stand here all night." It was not loud. That mattered. Cruelty is not always loud. Sometimes it is impatience with a person who needs more time than your evening wants to give. When Terrence stepped down, I noticed Isabel Santos reach into the bag, pull out a water bottle, unscrew the cap, and hold it near her mother without a word. Maria took one sip and gave it back. Small things in court matter to me. They show me what people have been carrying long before they got to the witness stand. Then came the third day. The third day is where cases often reveal what they have been hiding. The defense had spent 2 days building a story around distraction and stress. Ethan testified that his mother had been recovering from surgery, that he had been fielding family calls, that he was late for a dinner with a client, and that he was not proud of how rushed he had been. He said, "I had a lot on me that week. I heard him, I considered it. Pressure is real, family strain is real, but pressure does not empty a crosswalk. It does not put a pedestrian outside the law." And then the city called a witness I had not expected to carry so much weight. Her name was Denise Keller. She worked the front desk at Parkside Grill, the restaurant where Ethan Calloway had gone after the collision. The reservation log showed Ethan checked in at 7:28 p.m. That time mattered because it narrowed everything. The drive from Broad and Elmwood to the restaurant could be done in 11 minutes in evening traffic if a person was not staying with the officer, not asking after the injured party, and not thinking much beyond making the next table on time. Denise Keller testified that Ethan arrived agitated, handed over his keys for valet, and said into his phone, "If anyone asks, I've been here since 7. I asked her to repeat it. She did. The room went still in a way I can feel even now. You can learn a lot from a sentence spoken casually. It tells you where the speaker thinks the real danger is. That line did not decide the case by itself. Judges are not supposed to build a ruling around one sentence and call it discipline, but it did something important. It moved the defense from confusion to management, and once I see that shift, I start listening differently. Ethan Calloway took the stand again after that. His posture changed, less ease, more care. He said he never meant he wanted anyone to lie. He said he was embarrassed, shaken, trying to avoid public attention. He said, "I did not think she was seriously hurt." I wrote that down. It was quiet. It was still wrong. His lawyer did what a defense lawyer is supposed to do. Counsel argued that the state was turning poor wording into criminal intent. Counsel argued that Ethan had remained on scene long enough to speak with police and was not legally required to become a medic on the sidewalk. Counsel argued that the phone data proved only screen contact, not distraction. I listened to every bit of it. Fairness requires that I do. But there was one sentence from Ethan on cross-examination that stayed with me more than anything else he said. The prosecutor asked why he never contacted Maria after the incident. No apology letter. No offer to pay for her glasses. No check for the first urgent care bill. Ethan looked down and said, "I did not want to make it look like I was admitting everything." I wrote it down. Subscribe if this is the kind of story you want more of. That is the whole pitch. No speech, just subscribe if it is for you. During a recess that afternoon, I had a memory I had not expected. I was a boy again in my parents' kitchen. My mother was standing under the yellow light above the sink with one hand on the counter and the other holding her glasses. One screw had gone loose. We did not replace things quickly in my house. We fixed them and used them again. I remember my father finding a tiny screwdriver and my mother saying, "These still work fine." That memory came to me because of Maria's glasses on the evidence table. because I knew what it meant to rely on an ordinary thing until it became almost part of your face. Then court resumed, and the memory went where memories go when duty calls you back to the bench. By closing arguments, I had made my decision. I had made it before the final hour, if I am honest. But saying it out loud is different. A verdict lives one way in my notes, and another way in a room full of people waiting to hear what their lives will be called from now on. I looked at Ethan first. He was sitting straighter than he had all week, both hands flat on the table. No phone, no smile. Then I looked at Maria Santos. She had her folder closed and both feet planted. Her daughter was standing in the back by then because every seat was taken. I could hear someone in the gallery unwrap a cough drop, and then even that stopped. I found Ethan Calloway responsible on all counts before me. Failure to yield to a pedestrian in a marked crosswalk, use of a handheld device while operating a motor vehicle, negligent operation causing bodily injury, failure to provide full information to the injured party at the scene. I said each count plainly. The words were enough. The first reaction I noticed was not Ethan's. It was his father's. Charles Calloway lowered his head and pressed his thumb against his forehead for 3 seconds. Not long, long enough. Maria Santos did not cry. She let out one breath through her nose and touched the top page of her folder with 2 fingers, as if making sure it was still there. The verdict was not the hardest part of this case for me. The sentencing was. Because sentencing is where I had to decide not just what was permitted, but what fit the harm. Subscribe so you do not miss what I decided. I am getting to it now. I told Ethan Calloway to stand. He did. For the first time in the whole hearing, he looked toward Maria before he looked at me. Only for a second. Then he faced forward again. I had reviewed the order twice that morning. I knew exactly what I was going to say. I said, I am ordering you to pay a fine of $12,000 to the Rhode Island Hospital Trauma Recovery Fund within 90 days. I am doing that because careless driving does not end at the curb. It reaches emergency rooms, nurses, therapists, and every person who has to carry the cost of another driver's decision. I said, I am also ordering the suspension of your driver's license for 18 months, effective today. That means no personal vehicle, no company vehicle, no borrowed vehicle, and no hardship exception through family business. Driving is a privilege. You treated it like a private right. I said, I am ordering 200 hours of community service with Providence pedestrian safety outreach and crosswalk visibility audits. Those hours will be completed in reflective gear, in public, with attendance verified weekly. I am doing that because you need to spend time where people on foot stand and wait and hope drivers see them. I said, and there is one more thing. You will write by hand a 1,000-word apology to Maria Santos, and you will read it aloud at 3 driver education classes in this county and at 1 city traffic safety meeting open to the public. You will state her full name, the date, the time, and the intersection. I am ordering that because private regret costs little when public trust has been damaged. Then I said, you will also pay restitution in the amount of $7,416.82 for Maria Santos's unreimbursed medical care, replacement prescription glasses, lost wages, transportation to therapy, and the grab bar installed at her front steps because her injury changed how safely she could enter her own home. Those are not vague losses, they are exact. You will pay them. I did not raise my voice. I never needed to. The room was silent enough that I could hear a page turn at counsel table. Ethan swallowed when I mentioned the grab bar. Maria kept her eyes on me, steady, not asking for anything more than for the whole cost to be said without trimming it down. Then I spoke to him directly. I said, Mr. Calloway, what you did cost Maria Santos 12 shifts of pay, weeks of healing, 1 set of glasses, 1 safe walk home, and the plain trust that a marked crosswalk is supposed to give a person. I said, your family is not on trial here. Their money is not on trial either. But money has a way of softening small consequences before people learn from them, and I believe that happened in your life. His father did not move when I said it. I said, privilege carries responsibility. It does not excuse carelessness. It makes carelessness harder to defend. Then I paused and looked at him until he looked back at me. And then I said the sentence I believe most. I said, You knew enough to stop. You knew enough to stay. You knew enough to care. You chose yourself anyway. That was my response to the ego he brought into that room, not anger, not theater. Consequence. Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here. When the courtroom started to empty, I stayed on the bench until the clerk secured the file. Maria Santos remained seated for a moment. Isabel leaned down to help her stand, and Maria said very quietly, "He heard it this time." I remember that because it was not victory. It was relief measured in the smallest possible way. A few feet away, Charles Calloway put a hand between his son's shoulders and guided him toward the aisle. Not gently, not harshly, just firmly. Ethan held the sentencing order in one hand and stared at the paper like the words might soften if he kept reading them. They did not. The appeal came 27 days later. It was heard by the Rhode Island Superior Court Appellate Division. The ruling affirmed my judgment in full. The court said the findings were supported by the record and that the sentence was reasonably tied to deterrence, restitution, and public safety. It took just under 10 months. I was not surprised, but I was relieved. What happened after matters too. On June 11, 2021, Ethan Calloway came back before me for a compliance review. He had completed 158 of the 200 community service hours. The program director said he showed up for rainy evening audits near middle schools and never once asked to be moved to easier assignments. That did not erase what happened, but I heard it. Later that summer, he completed the public apology requirement. I did not attend, but the signed verification and transcript reached Chambers. In the transcript, his voice broke on the sentence where he had to say Maria Santos's name and the exact time of the collision. I read that line twice. Not out of satisfaction, out of caution. I wanted to know whether recognition had finally arrived. I learned something about Maria, too. On September 14, 2021, her daughter sent a short letter to the court. She wrote that her mother had started walking through Broad and Elmwood again, first in daylight, then after sunset the week before. At the end of the letter, Maria had added one sentence in her own hand. She said, "I still stop before I step, but I step." There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. This case left me with a question I still do not know how to answer. When does a person finally feel the full size of the harm they caused? At the verdict, at sentencing, when the money leaves their account, when they lose the right to drive, when they have to say the victim's name in a room full of strangers? I do not know. What I do know is that some people fear punishment long before they understand pain. They fear exposure before they understand consequence. And sometimes the law can force a person to stand still long enough for understanding to catch up. Not always, but sometimes. That is as certain as I am willing to be. If you are someone who has sat in a room while the person who hurt you spent more time talking about what the whole thing cost them, then you know the look I saw on Maria Santos's face. It is not only hurt, it is the exhaustion of realizing you may have to defend the fact of your own pain. If that feeling is familiar to you, I want you to know I saw it, and I did not let it get buried under polish and better clothing. And if you are someone who sees a little of yourself in Ethan Calloway, I want to ask you the question I could not ask from the bench. When did inconvenience start feeling to you like innocence? If you have harmed somebody, learn the full cost in their life before you begin explaining your own. Pay what you owe. Stay where you are. Say their name without rushing. I still think about those glasses. Brown frames, one arm missing, white scratch across the left lens. They were just an ordinary thing until one careless turn made them evidence. That is what stays with me. Not because they were rare, because they were not. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments are where people who care about the same things find each other.